So Ian, can you tell people out there who may not know who you are, exactly who you are, and what is it you do for a living?
Yeah, my name is Ian Corzine, of course, and I have a YouTube channel called Ian Corzine. And basically what I do is I help creators understand the law and maneuver brand deal and agreements as they go forward. And also my most recent venture is I'm moving into this new type of content out there in the metaverse and using blockchain technology. So I'm teaching people how to use blockchain in their businesses to actually make money.
During this Filmora lifetime license saga, there were a lot of questions that came up, and a vast majority of them were actually legal questions. And that's why I really wanted to have you on here, is that I hopefully could pose some of these to you. Now, I know that we have to probably indemnify you in a bit and say that this is not legal advice. This is just the opinion of someone who actually is an attorney.
Yes.
But there were so many questions that I certainly couldn't answer that I wanted to reach out to someone who actually was an attorney and say, hey, give us a little insight on what the reality is concerning the kind of questions and comments I got. So let me hit you with a few of these, and let's see if we can work through some of this and demystify it, not for only people who are watching my videos, but any creators out there who might be using software or using the platform and worried about how certain things might impact their ability to maybe potentially get channel strikes or copyright strikes along the way. One of the big questions right off the bat was the entire saga of the Filmora lifetime license user situation was really based around a thing that we were calling an EULA. Can you explain to people what an EULA is?
Yeah, sure. It's an end user license agreement. And basically it's a contract between the company who's producing the software and the end user, so to speak. And there's a couple of different ways that the contract gets formed. The first way and the most common is if you use this software, you are subject to this agreement. Oftentimes, there's also things where you load up a kind of software, you upload it, put it on your computer, and then you're required to go through the terms and conditions and then check mark, okay, I agree to this. But it's really a binding contract, a legally binding contract between the company that produces the software and that end user.
I know personally, sometimes you bought the software, you just assume everything is okay. You scroll down to the bottom and you click the box. Is it something that we really all should be spending more time with? What are your thoughts on, from the consumer end or the creator end, how seriously should we be reading this EULA, and how much can it matter down the line?
Well, there's a couple of questions there. You know, I have so much compassion for creators because I'm one too. And I am a lawyer who's trained in reading these agreements, giving advice about them. But I got to tell you, and I'm being honest here, there's often times where I just check mark the box too, or I scroll through the terms and conditions. So it's very hard, it would be hypocritical of me to say, yes, Daniel, every single time you use Google Drive or some other software, that you should go through the terms and conditions or the end user license agreement. I will say this, though. It is good practice, especially on the programs that you're using that are actually putting out art to the public. So I use Final Cut Pro. I think it's important that I understand what my rights are with respect to Final Cut Pro, because I never want to get in a situation where I'm accused of copyright infringement, or worse, somehow Final Cut Pro, I guess Apple, who owns the software, has some sort of ownership in the art that I put out on YouTube or TikTok or one of the other social media platforms. So I know it sounds like a lawyerly answer, but the bottom line is I recommend that with the most important software in your life as a creator that you do go through, because it is extremely important later on, as Daniel, you found out in this series of videos.
I absolutely found out, along with a lot of Filmora users along the way. So let me ask you another question that came up during this conversation. When a company changes its EULA over time, does the newer EULA, through different changes, if you take an update or an upgrade or whatever the terminology may be, is the original EULA affected by the new EULA? Is that even something that we can define, or is it a case by case?
I'm smiling to myself because for 20 years as a federal court litigator, I gave the same answer. And the answer is, it depends. But it really does depend. There are oftentimes EULAs where there is a provision in the newest end user license agreement which supersedes prior versions. There are times when they go together. In other words, version 12 goes together with version 13 and you have to review them all together. It's really a written contract. And what's great about global law, and especially United States law, is that we're free to write contracts for the most part however we want to. So that's one of the other reasons why it's really important for creators who are going to be using this software for a forward-facing piece of art to understand what's going on. It's not necessarily the case that a subsequent EULA, supersedes a prior end user license agreement.
So if consumers or creators were in a situation where they felt a company doesn't honor that EULA, what can a creator or consumer do in that situation?
Oftentimes, the first thing to do is go to the company, go to the website, register a complaint, go to LinkedIn and find the communications director or someone who's involved in customer relations and make a direct message to them, really explaining the situation. And what I always emphasize to creators is it's not enough to say, gosh darn it, it's not fair that you changed this version. You have to explain to them that you relied upon this existing, license agreement, and then you actually suffered damages. Damages is a legal term, but you suffered some sort of harm. In other words, now I can't afford to use this program, and therefore I couldn't put this video out. Generally, I'm making $1,000 per video, or whatever the harm is. You need to explain to them so that they can understand and then craft a solution. Sometimes they can give you a refund. Sometimes they can actually pay you or give you some sort of credit for future purchases. So that's probably the first step, but the other steps are kind of similar to what they were back at 30 years ago. Certainly file a complaint with the Better Business Bureau. The FTC, which is the Federal Trade Commission, has a new platform. It's called reportfraud.ftc.gov. And you can go there and you can report any fraud or any unfair business practice to the FTC. They're taking it really, really seriously these days. So you do that. There's those websites like the Ripoff Report, Piss Customer. You can certainly get some bad publicity for the company by registering a complaint there. And then the other thing is also something that doesn't occur to people is, the real prosecuting arm of a given state in the United States is the Attorney General. Not the federal attorney general, but the state attorney general. So you can actually go to your own state's attorney general's website and register a complaint there. And oftentimes, my luck is that I've seen creators actually do really well by complaining to the attorney general. No company wants a communication from the state's attorney general saying, listen, we're looking into your business practices. So you really do have some control. And then the final one I'll talk about, we can go into more detail, is filing a lawsuit.
That was one thing that was mentioned a lot. There was a ton of comments that I got on these videos where people would say, we should file a class action lawsuit. And this is exactly what class action lawsuits are for. The reality of that might be different than I think what people, imagine in their heads.
Yeah.
So do me a favor. Could you explain what a class action lawsuit is?
A group of plaintiffs who are similarly situated, the same harm and the same questions of law apply, decide, listen, we're going to file a lawsuit against Filmora. And then what we're going to do is we're going to petition the court to make it a class action so that we're going to be representatives of a larger group of plaintiffs, people who are seeking money from another company or another person, and file a lawsuit. Now, the class actions can be powerful because really it's a strength in numbers play. In other words, these companies generally have so much money and so many resources and attorneys and things like that. We individuals can't hope to succeed in all the difficulties that ensue with federal court litigation. Well, if you have a bunch of plaintiffs and you have some money pulled up and you have an attorney that's willing to do what's called a contingency fee agreement, where he or she only gets paid if there's actual recovery, then you can be powerful in the face of these other powerful companies out there. There's so many considerations to a class action lawsuit. It's not like you file a class action lawsuit and then you can expect it at the end of the year to make $56 or something for your damages. It actually takes years. You have to understand that the attorneys do a lot of hard work, and so they demand a high percentage of the overall recovery, which sometimes can exceed 40% of whatever is recovered. So there's a lot of considerations. We can go into more detail of those if you'd like, but I will say that it is a powerful remedy, but it is difficult to pull off. It takes time.
Does the fact that certain companies, in this case, let's use Filmora as an example, the Wondershare company, they are headquartered in China. Does
Yes.
the location of that company make a class action lawsuit for people who may be residing in the United States like I am. Not that I plan on filing a class action lawsuit, Filmora, but we're good. Yes. We're good. But if that was a company that was located somewhere else, does that make filing that type of lawsuit more difficult?
Yes, it does. You have to get jurisdiction, personal jurisdiction, over the defendant that you want to sue, or in this case, multiple defendants. And it's not impossible. And I will say that with class actions, it's actually easier because, again, the courts are, if you can convince the court that it's worthy of a class action, in other words, thousands of people were adversely affected, then oftentimes the court will do its best to be able to extend you all the courtesies needed to be able to get personal jurisdiction over another company. And I will say that Wondershare is doing lots of business in America. So if we were filing a U.S. federal court lawsuit, it would be not impossible. But I will tell you this: it costs a lot of money. It takes a lot of time, and class actions really work when there's so many plaintiffs with a large amount of damages. They don't work when there's hundreds of plaintiffs and the damages are $50 to $1,000. Those are not really economically viable lawsuits.
There's one other little point I'd like to talk about here, is that in the EULA, currently for Wondershare Filmora, there is a governing law and dispute resolution clause, number 20, which reads, "The agreement will be governed by the laws of the People's Republic of China without giving effect to the conflict of laws. Any disputes arising out of or in connection with this agreement shall be settled by the Sichuan Court of International Arbitration in according with its effective rules to the extent not prohibited by local law in your jurisdiction." Decipher that for me.
I'm glad this video is not going to be on TikTok, because it would be immediately taken down. That makes it more difficult, right? What you would do if you were a federal court litigator is you say, listen, the remedy available if we honor this license agreement is insufficient. And you would be able to demonstrate evidence of, Chinese courts favoring Chinese companies, Chinese courts taking super long to adjudicate any disputes. Maybe you could even reduce evidence of no one ever winning in a Chinese court, something like that. And you might be able to say, listen, I request the court abrogate this agreement with respect to this provision to allow a large group of people who are adversely affected to be able to have their day in court here in America. But as you can tell, me making that argument off the cuff, that's going to take research, that's going to take briefing, that's going to take court hearings, and it's going to take money, frankly. So yeah, that makes it more difficult to proceed with a class action in America.
So another hurdle in terms of what the options are.
Yes.
There's a reason I chose the option that I did, which is I felt that what we needed to do as a community was spearhead a movement of public sentiment. If enough of the consumer base spoke out and said something, that we had the best chances of getting the company to react and respond. In our case, we were very fortunate. The videos that I put out got a lot of traction with not only Filmora users, but non-Filmora users who the idea of the story struck a chord with them, the sort of David versus Goliath feel of this, which is sometimes what people feel when they're trying to, negotiate or talk to a corporation. So that ground movement worked out. But another thing that was mentioned along the way, which I have to put a huge caveat before this, and I've said this before, one of the things that people have said was, that's why we pirate the software, or we crack the software and steal it.
Yeah.
The one comment I made that took an overwhelming majority of people who had my back and made them pause and some of them turn on me was when I said I thought that pirating software in any way, shape, or form was the wrong choice for a variety of reasons.
Yes.
One being that it's illegal. Mm-hmm. The other reason being that I don't feel it hurts the company. I think piracy in general does hurt software companies, but it's happening every day. And as long as people are purchasing, pirating, whatever the thing is happening, the demand is still there for the product. What really hurts companies is when the demand disappears and there's no need for anyone to want it. That's what makes companies stand up and take notice. That was my opinion. And I had said, my analogy was, even if you had paid for a license and you felt that Filmora was not honoring that license, going and deciding to then pirate that license would be like the bank messing up your deposit and you couldn't get to your money, so you decide to go rob that bank.
Yeah.
And I didn't think that that made sense. What can you tell us from your perspective, your thoughts on piracy and trying to crack software and the implications for people who may actually think that that's a viable alternative?
First off, I would advise as your legal counsel that you don't rob banks.
Okay, thank you.
That you don't do that. But like your analogy, I agree. I don't think piracy is the answer. I think that even if you were to go with this eye for an eye type principle that's existed for, since humanity started, I think in this day and age, you underestimate the power of corporations, especially Chinese corporations, and you're asking for a lot more problems than I hate to be, I don't want to put this down, but that the fact that you can't use this one video editing software in the future causes. So I would agree that piracy is probably not the answer. You're asking for a potential copyright infringement lawsuit, a breach of contract, breach of the license agreement that we talked about before. So there's a lot of problems with that. And also, I think that it's not super effective. I mean, I think like you just said, I think that, if you have 10,000 people pirating the software, they don't really freaking care, right? I mean, I think what they do care is, you said, decrease in demand, absolutely, but also a public stink, I'll call it, which is just what's kind of happening right now with your videos. And also the fact that you're really kind of, you're representing the consumer, and it's a larger issue. It's not just video editing software, it's software, it's social media platforms. You're kind of taking this to the level. And I think you're starting to feel that there's this anger out there. Well, this anger is powerful. This anger can be used to be able to make these people follow their own rules and deliver value to the customers that have paid their hard-earned money, especially in this time of the economy where people don't have any money. So I would advise, just as being your counsel, that, probably the more effective way is to bring this to the public fore, to make the FTC complaint. These people need things to do. They are looking into these complaints. Go to the Attorney General. Even complain on these rip-off websites. These are things that actually make an impact and can force these mammoth companies, even if they're in China, to actually comply to consumer demand.
I had that very same feeling when we started down this road only a couple of weeks ago.
Yeah.
My thought was that there was probably someone in a meeting, this is only my opinion, that saw the potential to drive more revenue somewhere along the line to say, why don't we end the lifetime license policies we have and swap them over to subscription only, because on paper, that would mean X in terms of revenue that we could drive above and beyond what we're already driving.
True.
And I think what got undervalued in that conversation was behind closed doors in a corporation, you don't really have that dollar value on public sentiment.
Yeah.
And a groundswell of consumer-based opinions out there that come together as a unified voice, the way so many great people did in this situation, has a value to it, and it has a negative value to the company.
Yeah, I agree. And I think that they missed an opportunity. I think these days, the public is clamoring for truth and communication, adequate communication. And I own companies right now, and, we're not doing the best in the world. It's a hard time for us. So what do? Do we just make financial decisions and we don't consider the end consumer? No, we communicate. So one of the viable ways for Filmora to have done this is just say, all right, guys, listen, I got to tell you, we're not doing that great. And so what we're going to have to do is we're going to honor what we've said in writing in these agreements, in these contracts for a period of time. But our next software, unfortunately, we're going to have to offer on a subscription basis. That's the only way we can make it work. It kind of reminds me a little bit of what Elon Musk is doing with Twitter right now. And you can criticize, you can say he's horrible and whatever. I don't care about that part so much. But what I understand is Twitter is almost a bankrupt type corporation. He is doing his best to be able to revise the situation and get some positive cash flow into the company. And so he's saying, listen, guys, I hate to say it, but you can get a check mark if you pay $8 or $11. So at least there is some communication that's helping us understand why now we got to pay money to Twitter. The same could have been done with Wondershare or Filmora. They could have just come out and said, listen, guys, we're so sorry, but we need to bring in some revenue. And so we're going to have to change this thing. And that way it gives the consumer a choice.
Yeah. That was one of the things that really got to me off the top of this conversation. It really stuck in my craw. Was I felt very much the same, and I verbalized that in my first video, that I thought transparency was all of it. Yes, you would get some backlash if you ended using the lifetime license agreements. I understood that, but the fact that it happened at the same time the new thing dropped, and he just sort of said, "Oh, this was your mistake. You didn't read the ELUA properly, or you had misunderstood," and I think it belittled the very people who had supported them from the beginning. My gut was, there's a reason that companies offer lifetime licenses, which was another thing that was brought up, that people have said lifetime license policies in general are unsustainable as a business model. And I agree. But also in this case, Filmora had ended their lifetime license policy years ago. You couldn't even purchase a lifetime license anymore. So at that point, it was something that corporations use, much like crowdfunding. Yeah. Pay a little more, invest into a product that isn't fully developed yet. It's something that's newer. We're still working through it. Where it is today is not where we expect it to be 4 or 5 years from now. But in this transaction, you'll pay a little more, but what you'll get in return for giving us more money is we'll offer you perks that people down the line won't be able to get. That's sort of crowdfunding in a nutshell, isn't it? So yes, my thought here was that I felt there were some comments that said to me, "Hey, Daniel, why are you putting up such a stink over $59, $69, $79, whatever anyone paid at the time?" And my real thought was, well, yeah, that was me. If the argument is there are so many lifetime license holders that it's hurting the company, then multiply what the aggregate is, $60 times 1 or 2 million viewers, and you're talking $60 to $120 million that people invested into the crowdfunding efforts of Wondershare Filmora. And they had an expectation for putting that much money up front. So it wasn't just my purchase. It was really, I felt it was the purchase of everybody who came together and were promised as almost like investors in the product. We put our money up there and said, we know it isn't where it will be later on. We know it's going to grow, and we'll invest now and spend that money hoping that down the line, the product will only improve and we'll all reap the benefit from it. Now, speaking of creators and consumers, and saying things on the platform and what we're allowed to say and what can get us in trouble, this opens up a can of worms that I always get nervous about. But one of the other conversations that came up in here during this saga was there was some back and forth from Filmora where they actually had threatened to take legal action against anyone who may have said something on social media that they found to be false or malicious, and that they would take legal action.
Okay.
I was somewhat shocked by that. I made my opinion clear. I thought that was a bit of a weird thing to add on to the fact that they were now trying to make an apology and offer an olive branch along the way. Didn't make a lot of sense to me personally, but I thought it was more of a weird veiled threat to try to stop people from talking. Like, okay, we've done the right thing. Please stop saying bad things about us. And I can understand that, at least from a company standpoint. I didn't understand it from a good PR standpoint. Yeah. But it did bring up the question of, what exactly is free speech in the United States? When we talk about free speech, this is a deep one. Could you just give us a general feeling of what we mean here? Do we mean, hey, you can say whatever you want on social media, it's protected by free speech? What does free speech mean?
Thank you for asking that question. I've spent a lot of time analyzing it, and I got to tell you, I got to give you some context. You're talking to a free speech absolutist. No, I'm not like Elon Musk, but I am a big free speech proponent. I believe that free speech is something that we need in democracy so that we can debate ideas, and so we can push down bad ideas so that we have good speech to throw against bad speech. So I'm really open, and I tend to agree with the U.S. Supreme Court that there are really only limited examples of when someone expressing themselves. And when we talk about speech, it doesn't just mean like me talking. It's also about me communicating through, any kind of verbal medium. So, if you're trying to incite imminent harm or a breach of the peace, that's an exception to free speech. If you're making false statements, whether they be in the commercial context or the publication context, like being on YouTube and things, and that causes damage, that's not protected. But in my humble opinion, everything else is fair game. So what it appears like the company has said is, listen, we're going to, sue for defamation anyone who starts making false statements about the product. Now, if there are false statements, then there's potentially a viable cause of action. However, when you sue for defamation, you also have to prove damages, right? So you have to prove that Joe Swanson, one of your commenters who said that, this is the worst software in the world, it doesn't work, or something like that, actually caused Filmora and Wondershare damages, which is virtually impossible. So I would view what you received as just an empty threat, because free speech is, especially in America, is virtually unlimited except for the exceptions that I delineated.
Well, let me dive into that for a second.
Sure.
There could be an argument made that I was more of the center figure for the conversation regarding lifetime licenses. I wasn't the only one who talked about it. I wasn't the largest channel on YouTube that talked about it, but I certainly was the one that a lot of people sort of campfired around and were paying attention to and reacting with to sort of keep up with what was happening.
Mm-hmm.
Certainly this forced Filmora to change their licensing policies, which would force them to technically lose some revenue, potentially, depending on how it worked out. I don't know the argument you'd make there. Would something like that, me saying, this is what's happening, I'm not a fan of it, I think you guys should reconsider, if that forces them to make a change that they lose money in, is that the kind of thing that is not protected by free speech because it caused them harm and it could be considered malicious?
No, it is absolutely within your right to state true facts that potentially are negative. So no, just because they may have suffered damages as a result of your efforts doesn't mean that you are liable for defamation, because they have to prove that you're making false statements about the product. And I know you as a person, known you for a long time. You don't make false statements. So I absolutely disagree that there's any cause of action against you or any leader out there who's saying this is BS. You said this on one occasion and now you're saying this and it's hurting us, the customers.
Ian, I'd like to thank you so much for being here, for not only helping me learn a little bit more today, but helping anyone who might be watching learn a little bit more today. So thank you very much for being here, my friend.
Hey, thanks. And also, I just want to thank you from all the voices out there that need to be heard, that are getting screwed in this situation, that you're really helping them. So it means a lot to us that a person who, represented the company understands that there's some real problems that need to be corrected. And so I'm looking forward to your future content on this.
Thank you, Ian.